Hi, everybody. Thank you for coming. We're waiting for folks to file in from the waiting room. We'll get started in a minute. Thanks. Hi, everybody. We'll get started in a minute. We're just waiting for folks to file in. Thanks. Hi, everybody. Thank you so much for being here. My name is Bethany Davis-Knoll. I'm the Executive Director at the State Energy and Environmental Impact Center at NYU School of Law, where I also teach a class on government lawyering. We'll be talking about this past term in the Supreme Court today with top appellate lawyers from 4 states and Kirti Datla from Earth Justice as our moderator. Spoiler alert, administrative law, environmental law, and states' rights are changing before our eyes. These great attorneys are going to help us digest these events. We'll start with brief intros and some logistics, and then I'll turn it over to Kirti to lead the discussion. And we'll drop the longer intros into the chat so you can read about our speakers. Ben Gutman is Oregon's Solicitor General. Mithun Mansinghani was the Solicitor General for the state of Oklahoma until just recently and is now partner at Lahotsky Keller in Oklahoma City. Lindsay C. is Solicitor General for West Virginia. And Stephen Wu is currently Chief of Appeals for the Manhattan DA's office, but just previously he was the Deputy Solicitor General for the New York State Office of the Attorney General. And Kirti is Earth Justice's Director of Strategic Legal Advocacy. I'm so grateful to all of you for being here to have this discussion with us. And I also want to say I'm extremely grateful to the State and Local Legal Center for co-sponsoring this event with us, and to the Conference of Western Attorneys General and the National Association of Attorneys General for your support in helping to spread the word. A few logistics before we get started today. First, CLE materials are in the chat, and we'll be dropping links to the SCOTUS blog pages when speakers mention different cases. We will be announcing a CLE attendance code for those of you seeking CLE credit. Please keep track of this code as you'll need it to certify attendance on the survey at the end of the event. The chat is closed, but please feel free to put your questions for the panelists in the Q&A, which is right next to the chat at the bottom of your screen. Your questions will not be visible to other audience members, and we do not tolerate discrimination, harassment, or bullying in the comments. We will moderate accordingly. We will fold your questions in as best as we can. If we don't get to your questions, we will save them for future programming and are grateful for them. Okay, Kirti, the floor is yours. Thank you.
Thanks so much, and thanks to everyone for attending, and to our amazing panelists for sharing their thoughts and wisdom with everyone here. So we did a preview of this term earlier this year, and we talked a little bit about the shadow docket, which is the sort of series of orders that the court issues that's not part of its certiorari or full merits docket. And the court issued some big decisions or orders related to the COVID crisis on its shadow docket this year. So Stephen I'm wondering if you could tell us a little bit about what happened in those cases, and also whether you think they tell us anything about the kind of trend of the Supreme Court's use of its shadow docket going forward.
Sure, and I'll start by saying I'm glad to be back with this group of individuals here to talk about the Supreme Court term, and always appreciate the invitation to speak to this group. So the court considered a number of COVID-related cases, but the two that we wanted to discuss here involved challenges to COVID rules issued by federal agencies, because as Kirti said, they gave an interesting insight into the court's thinking about agency power and a preview of what it said at the end of the term in the case that Lindsay will discuss. And the court also came out in opposite directions in these cases in ways that raised some interesting questions. So one case was called NFIB versus OSHA, and it involved a rule issued by OSHA, the Occupational Safety and Health Administration, that required all employers above a certain size to have their employees vaccinated against COVID or undergo weekly testing. The second case, Biden versus Missouri, involved a rule by CMS that required Medicaid and Medicare facilities to give the COVID vaccine to their healthcare workers on pain of losing federal funding. And both of these were subject to emergency litigation by private groups and by state plaintiffs. And on emergency appeals to the Supreme Court, the court granted a stay against the OSHA rule, the one about workplace COVID vaccinations, but denied a stay on the CMS rule, which is about hospitals and other healthcare facilities. And although I'll end up describing the rulings as coming from the majority in each case, I think it's worth noting that only the Chief Justice and Justice Kavanaugh were actually in the majority of both cases, and so they were the dispositive votes here. For the OSHA rule, the workplace rule, the majority concluded that the agency likely lacked authority to promulgate a vaccination or testing mandate. And in an application of the major questions doctrine, which we'll talk about much more in a bit, the majority said that the rule had such a significant effect on so many employees, right, 84 million workers by the court's count, that Congress had to speak clearly to give the agency authority. And the court said there wasn't statutory authority here because it drew a distinction between OSHA's power to regulate what it called workplace or occupational hazards and something that it did not have the authority to regulate, which is what you might call, and I'm quoting here, the hazards of daily life, right? Universal risks, day-to-day dangers, not affiliated or specifically affiliated with the workplace. And the court found that COVID policy was dealing with the hazards of daily life, right? The daily life that all of us lived through for the last 2 years, as opposed to workplace specific standards. And so therefore was outside of OSHA's authority. But the court reached the opposite conclusion for the CMS rule and found that the CMS rule was within the agency's authority. And there, the court didn't seem to apply, at least the majority didn't seem to apply the major questions doctrine. But what it said was that CMS was explicitly authorized to impose conditions on funding for the interests of health and safety. And it just said that a vaccination requirement was, of course, serving that exact purpose, the health and safety of both the employees and the people served by Medicare and Medicaid. But the contrast between the cases that I think is most interesting is, I think, how the court talked about the broader context behind both of these rules. And the majority in the CMS case noted two features of the CMS rule, again, about healthcare facilities, that supported its validity. One, it noted that CMS had routinely imposed qualifications on healthcare workers, including things like sterilization and hand washing requirements to keep things clean. And then secondly, and more specifically, it noted that vaccination requirements were widespread. They were required by hospitals, by states. They were what they called a common feature of the provision of healthcare in America, and therefore were non-controversial. And the OSHA case was different. There, the court said that OSHA had never imposed a similar vaccination requirement. The scope of the rule was unprecedented. And so this was something new to OSHA. And I think because of that distinction in the context, sort of whatever the underlying statutes, that sort of explains why the court ended up ruling in one way for the OSHA rule and another way for the CMS rules. Just super briefly, because Kirti had asked about the implication of these cases. I think a couple things were already true before the current year shadow docket, right? The court is obviously interested in entertaining these applications and ruling on them very briskly. I think what these two cases make very clear is that the court is not only interested in entertaining these applications and ruling on them, but also interested in saying important substantive things in these shadow docket orders. I think, these decisions ended up, cited previous shadow docket orders, such as in the Alabama Realtors case. And these two orders ended up being cited in the West Virginia case, which Lindsay is going to talk about. And the last thing I'll say is I think what is interesting is that the court is plainly interested in doing this, entertaining these applications and saying substantive things, even when the same issues are present in their normal docket, right? Like it is not an obstacle for them to say something about it when it could affect a pending case. And that's the one piece of this that I thought was a little bit new from this term, is that it's becoming much more just an early merits ruling as opposed to a truly emergency litigation that litigants aren't supposed to read that much into.
Thanks, Stephen. So one interesting thing about these two cases that you just discussed is that the court actually heard argument in them, which is sort of unusual for a stay application. And I'm wondering if you think that reveals something about kind of the pros and cons of the court deciding big issues in this way, if they felt like, they actually needed the benefit of argument, but didn't also have the benefit of, for example, full briefing in this case, and maybe just kind of generalize about how, the whether, maybe if you want to offer an opinion on whether the Supreme Court should be doing this or not, but at least kind of discuss the pros and cons.
Yeah, I think the fact that there's argument is like a good sign that the court recognizes that these are no longer, truly temporary things that can be decided very swiftly, but instead merit some further consideration. And argument is an important step to recognizing that. I should also say, I don't think anybody's disputing that there's a need for emergency practice in front of the Supreme Court. There are always going to be emergent situations that need to be dealt with very quickly by the court. But, and I think I said a version of this last year as well, there are definitely downsides to the process. I mean, it is a very taxing process to go through this litigation, both for the litigants and for the court itself. And I at least worry that it undermines the court's ability to pay full attention to the issues before it and to think through the implications of its rulings. It's especially a problem, I think, with these complex administrative cases. I mean, these two rules that were at issue in these two cases, and again, these were just two of the shadow docket cases from this year, totaled over 200 pages, right? And were, whatever you think about the process leading to these rules, they were the product of like large staffs in these two agencies thinking about the problem, putting things in the administrative record, trying to at least reason through and explain on the basis of facts why they needed these different policies. And, as a litigant, it's very hard to process all of this in the time frame that emergency litigation gives you. I have to imagine it's difficult for the court too. And I think it's a very tricky balance to, as I said, have the court, address true emergencies here that will affect millions of people. And that's how the court quite legitimately saw both of these challenges, while at the same time being able to fully consider the arguments and issues and the facts in all of these cases.
I want to give the rest of the panelists a chance to pick up on one or two of the things that Stephen just mentioned. One of them I thought was interesting was the comment or the preview of how shadow docket decisions were kind of used in a later merits decision that, as he mentioned, Lindsay is going to be discussing. And the other is this kind of pro-con consideration of the shadow docket. So I just want to make sure other folks have time to jump in if they have opinions.
Yeah, so I mean, I think that the developments this term are that attempt to strike that balance of the necessity of the shadow docket with giving it as much of a full hearing as possible. So you saw it in these two vaccine mandate cases, but then you also saw it in Ramirez v. Collier, the Texas death penalty case, as well as the Texas abortion SB8 case. I think it was another whole women's health case, but the name escapes me. And so those were cases where, again, I think 4 cases argued this term on the emergency docket. I think is fairly unprecedented. So I think the court is taking seriously the attempt to draw that balance between having these necessary emergency docket issues and giving them the full and fair hearing that they deserve.
And I think I'll jump in on that. I agree with all of that. Something that's new from the last time that this group was together and we're able to talk about this issue is seeing the arguments on these shadow docket cases. And so I think it is a sign that we see the court recognizing some of these concerns, in the public discourse about what does accountability look like and what does transparency look like. But trying to balance these factors is difficult. And there's a lot of value for the litigants and for the court to be able to sit with something for the time it takes to work through a merits case. Certainly, all of us have had the experience of needing to move quickly, and there's a lot of talented attorneys who can do that. But there's also value in the way that the process ordinarily works, of being able to let those issues marinate. So I think striking that balance is always going to be a challenge for the court. And one of the things that I'm really interested to see in this going forward is if we are going to have more of these argued shadow docket cases and they're going to have opinions attached to them, how is the court going to view the precedential effect of those opinions? Certainly we've mentioned that there was the stay in the Clean Power Plan case, which was certainly influential in the West Virginia decision that I'll talk about more in a minute. But something that was interesting there is we didn't have a detailed opinion that everybody was talking about at that point. It was the fact of the stay, which was important for the litigants, but it's not quite the same thing as we're seeing this year with reasoned opinions at the stay stage. So that's something that I think we should be looking for, is how is the court going to weigh the value of these written decisions?
Thanks, Lindsay. Well, why don't we stick with you and go right into a discussion of, one of the biggest, perhaps the biggest environmental and, certainly the biggest environmental, but biggest administrative law case of the term. So we've already mentioned that it's West Virginia versus EPA. Most of the people on your screen participated in the case in some way or the other. And Lindsay, you argued the case for West Virginia and of course led the briefing. So can you tell us, just briefly what the case is about, but mostly deeply what the court actually held in this case?
Of course. And so to start, I'm not just saying this because of who is on this call, but one of the pleasures about this case is I think it was really well litigated on all sides. There were a lot of important voices before the court. I was able to lead for West Virginia, a coalition that included states like Oklahoma, where Mithun was. Stephen wrote really fantastic briefs for a group of states on the other side that included Oregon. So it's a pleasure when we have cases like this to be able to have really strong advocacy on all sides of the issue. So talking about, first of all, what this case is about and what the court held, I will try to be brief on this because, of course, it's a complicated case, as a lot of these administrative and environmental law issues are. But essentially, the question came down to what power did or did not Congress give to EPA when it comes to regulating buildings, in this case, power plants, to be more environmentally efficient with their carbon emissions. And the particular provision of the Clean Air Act at issue is Section 111D, and that sets out a partnership between the federal government and the states. EPA has a role to identify what the best system of emission reduction is for a category of sources. In this case, we are talking about fossil fuel-fired power plants. And then once EPA sets that best system, then the states are responsible to come up with a particular standard of performance that reflects that best system for each of the sources within their borders. Now, this particular provision had been used a handful of times over the years. There was some dispute about how broad some of those previous rules went. But in our view, all of them, or at least almost all of them, to be fair to everyone on this call, those previous rules had really focused on the idea of what can a particular source do to reduce its own emissions? What is something that particular power plant can do? So that's where it had been used in the handful of times before. That changed in 2015 when EPA issued the Clean Power Plan. And what that rule did, it was self-consciously supposed to be transformative. It said those sort of source-specific emission reductions weren't going to be enough to get the degree of emission reductions that the agency was hoping for in that case. And so it went beyond what the particular sources can do and said, all right, let's look at the energy sector as a whole, and let's use these tools of cap and trade or generation shifting so that essentially one source, like a coal-fired power plant can reduce its own operation, and then it would have options to invest in other sources of energy, to have perhaps credits. So there's this ability to sort of shift who is producing electricity in the nationwide power sector. And then the idea is overall that would dramatically reduce emissions. So that was the theory of the Clean Power Plan itself. There were a lot of changes back and forth with the rules, which I'll talk about in a minute, because I think the jurisdictional holding is important. But to cut to the end, what the court ended up holding at the end of this 7-year saga is that this question about who can be in the electricity generating sector, what should be the composition and the division between fossil fuel fired and renewable energy production, how does that break down on an economic and an energy grid reliability standpoint, that is the sort of major question. It has significant economic and political consequences. And the court said, this is the sort of extraordinary case where Congress has to speak clearly in order to delegate that authority. And the court concluded this was that major questions case, and Congress did not give that clear statement. So that's my attempt at a short explanation of kind of what led us here. So let me then move back to the jurisdictional issues, and then I will end. Sorry, I didn't put my phone on mute. And then I will end with the merits again. So when it comes to jurisdiction, this was an interesting ride up to the Supreme Court because, as we just talked about, that Clean Power Plan had been stayed by the court, so it never actually went into effect. And then we had a new administration that came in. So the Trump EPA announced that it was going to repeal the Clean Power Plan. It ultimately did. It passed its own rule, the Affordable Clean Energy Rule. And that went through the DC Circuit. And the DC Circuit issued a decision the day before President Biden's inauguration that said that decision the Trump EPA had made was invalid because the EPA had said the reason that we are invalidating the Clean Power Plan and putting this new rules in place is because we read the statute to say we are only allowed to regulate at that source specific level. That's the only option Congress gave. The DC Circuit disagreed. Then, of course, we had another administration that came in that announced that it was going to, take a third path. So that was the position we were in when we went up to the Supreme Court. So there was this question of what is the particular rule before the court here? And when the court looked at that issue, it was a significant portion of the briefing. But one of the things that I find significant about the majority opinion, it's a fairly breezy discussion of these jurisdictional issues. It's about 2 pages. And so the court really looks at this from a black letter law standpoint. There had been arguments in terms of standing and mootness, and the court said, appellate standing is required, but that's a fairly low bar. We look to the judgment itself below, and the effect of the DC Circuit's judgment is that the Clean Power Plan could come back to life, and the ACE rule was taken off the books. And the court said that's enough for standing. So everything else, these questions about whether that in fact would happen, whether EPA ever would reinstate the Clean Power Plan, those are all mootness questions. And that's a really high bar for the party who's saying the court shouldn't exercise jurisdiction. And even the dissent really didn't take issue with that. In Justice Kagan's dissent, she said, the mootness standard is a notoriously high bar. So on the black letter law, there really wasn't a lot of disagreement from the court on this. Where the disagreement did come is these pragmatic factors of should the court have taken the case. And the court doesn't say much on that, but some of the arguments there were, look, this is something that happens all of the time, or at least this is not a unique case because we have this back and forth with different administrations. Rulemaking takes a long time. A lot of industries need to know how to plan in terms of what the rule of the road is going to be. So those were some of the arguments there. And then, of course, on the other side was this idea of, is there a concrete enough issue for the court to decide? Now, of course, we argued there was, we thought that there was just a pure legal issue. The facts didn't matter as much for the court to resolve that question. But I think it's significant. It really did come down to some of those pragmatic issues of whether the court should decide it. And so I think this is a holding to watch because we're going to keep seeing these sort of cases come up on the docket. We'll talk about the Sackett case for next term later. That's another one where we have seen the rule change back and forth with the past few administrations. So the court's willingness to give an answer on these issues, I think that's a portion of this decision that could be important as we see a lot of these cases moving forward. So then, of course, that brings us to the merits of this major questions doctrine. A couple of things that jumped out to me in the majority's opinion is, first of all, the Chief Justice, it seems really important to him to emphasize this is not a new doctrine. He goes back and cites through several decades where the court has talked about this. as Stephen mentioned, even this term we had in the COVID cases, major questions analysis. What is new here is that the court had never actually named the doctrine in the majority opinion in that way. And the court also used the doctrine in a different way. There had been a lot of questions about, if this doctrine is a mode of statutory interpretation, where does it fit in the analysis? Is this some part of Chevron, or how does this work? And what the court said here is it's a distinct type of statutory analysis. So in this extraordinary class of cases that involve a major question, these issues of significant political and economic authority, it actually doesn't matter even if the agency has a plausible reading of the statute. It's the language the majority opinion used. Even if the agency, can say, here we go, I think here's how we get here under the statute. The court says it's not enough. This distinct form of analysis says we're looking for a very clear statement that Congress in fact delegated this, which is an interesting holding, because I think as we were looking at this, I think there were strong signals the court was interested in saying something about major questions doctrine, but the justices had really different views about it. So I was frankly a little bit surprised to see 6 justices who signed their name to an opinion that was that strong about the role that it plays in the analysis. And then I will end briefly with a couple of things that the decision did not decide. So I think one of them is this question of, all right, we know major questions doctrine is a thing for the court. This is something that lower courts need to do. But the court was not clear what factors are going to be necessary or sufficient for cases going forward. The majority opinion talks about a number of them, but I think this is an area where there's going to be a lot of work to do in the lower courts to really work out what this means. Justice Gorsuch's concurring opinion lists some factors. And so I think that's going to be another interesting question. Are courts going to treat that as effectively restating what the majority said? Is it something different that was only signed by 2 justices? So there's a lot of unknowns in how the doctrine applies. And then the last thing is the majority didn't actually answer what this statute allows and doesn't allow. What it said was the statute does not allow this sort of generation shifting based model that EPA had used in the Clean Power Plan. It did not say if EPA is limited to source specific measures or not. So that's another area where in this particular context, EPA will have to work out what that means and what is still on the table and what isn't.
Thanks, Lindsay. So you mentioned that the court maybe left some things open with its decision about what the major questions doctrine means. And so I suspect the rest of the panel might have some views on what the opinion means. And Ben, can I start with you and ask if maybe you can offer some clarity about what you think the opinion, when you think it'll apply in the future?
Well, I wish I could offer clarity, but just to pick up on something Lindsay just said, I mean, all we know for sure from the majority opinion is that it applies in extraordinary cases, which presumably means it doesn't apply in ordinary cases. But I don't think we know really what that test means. And to me, that's of great concern. I mean, the way, as Lindsay was describing it, the way the majority applied the major questions doctrine here, it essentially says that in these extraordinary cases, the court will ignore the most natural reading of the statutory text that Congress enacted, and instead, look for some super clear statement from Congress about what it intends. And the dissent characterized this as a get out of text free card, and I think that is potentially how it can be used. I mean, probably most cases the Supreme Court reviews are extraordinary in some sense, or the court wouldn't have taken them. But that gives no real guidance to the lower courts on how to tell extraordinary from ordinary cases. And my fear is that extraordinary is such a malleable standard that, essentially judges can invoke it whenever they have a strong policy disagreement with an agency, which I would think is exactly the sort of result-oriented activist judging that we were trying to get away from with the Chevron doctrine in the first place, and that, that conservatives have long decried. So I think we'll have to see, it'll take a few more cases to see how this actually plays out, both in the Supreme Court and probably in the lower courts too.
And just to give some, detail on that as well, because I agree with Ben and Lindsay that there are some open questions on this doctrine. I think a lot of this fight is going to be on the framing of what the agency has done and what practice has been. And I'll raise a couple of specific points that came up during the litigation as the parties were fighting over the application of the major questions doctrine. One question, for example, is whether something is novel based just on what the agency has previously done or what the industry that is regulated by the agency has done. And I think this was one of the points that came up during the argument. If you look just at what the agency has previously done, which I think it's fair to say the majority did here, then it's a much more narrow set of prior rules, as Lindsay acknowledged, right? Like most rules were different from the Clean Power Plan, and the court disposed of the one prior rule that had been raised as an analog to the Clean Power Plan. But if the framing instead is, what does the industry do? Because that's the world in which the agency participates, you might have a different answer. And I think one of the things that the respondents had tried to argue was that, you know, the industry had engaged in these sort of practices and the agency was just sort of following on to what the industry had done. But these are two different ways of seeing like what's novel and what isn't. And the only other way I'd mention is that the parties also did, I think the petitioners especially did a good job of characterizing the Clean Power Plan and the ACE rule in a specific way. You know, Lindsay doesn't give herself enough credit when she says that the court characterized the Clean Power Plan as one where EPA was in the business of picking like the who would participate in the electricity generating sector. That was a contested characterization, but that pitch to it in the petitioner's brief ended up carrying the day. And I think it was a big deal because if you see this rule as one that is picking winners or losers in a certain sector of the industry, that seems major, unprecedented in a particular way. You know, there's a different way of looking at the rule, which is being extraordinary, but in a totally different way, right? And one of the things the Clean Power Plan did was that it swept into its regulatory ambit, not just traditional emitting sources, but also zero emitting sources and other sources that hadn't been covered by EPA before. And if you see that as the extraordinary nature of the rule, then I think a decision invalidating that part of the rule looks very different and has different implications than one that says instead that the EPA, you know, can't sort of identify who should generate or not within the electricity sector. But anyway, these are different ways of looking at novelty, and because they have to do with the threshold question of when the major questions doctrine is implicated, I think how those play out in the future is going to have a major effect.
Thanks. So Chevron just came up, which is a doctrine about when courts will defer to an agency's interpretation of ambiguous statutes. And it didn't come up in West Virginia, which has to do, I think, with somewhat complicated procedural reasons about how the case was litigated that aren't that relevant for this panel presentation. But it also didn't come up in other aspects of the court's decisions this term. So I just wanted to see if any of you had views on what we should take away from the kind of silence about Chevron deference from the Supreme Court this term.
You know, I can start on that one. I think one of the things that's interesting about Chevron this term, and it's actually not unusual from other recent terms, is how infrequently we hear Chevron from the court. The court had a couple of cases where the question of should we still follow Chevron was front and center before it and didn't even talk about it at all. One of the things that I thought was really interesting is reading the religious freedom case and the Coach Kennedy case at the end of the term, and the way that the court talked about the lemon test that had been used there. It didn't officially overrule it, but it spoke as if, well, all these silly lower courts, why have they been applying it? It's been clear that it hasn't been something that we've applied for a long time. And so I think there's been some discussion of is Chevron going the same way? If the court's just not going to talk about it, are we going to hear a similar decision in a number of years that says, well, we haven't applied Chevron for a long time? And I think that is something that we found interesting in the West Virginia case. It is true that was not litigated, but the reason was because the EPA, when it repealed the Clean Power Plan, it said we're starting at Chevron step one. The reason we don't need to get into agency deference is because we think the statute is unambiguously clear. We only have one option. And the court didn't agree with that. You know, the court, there's certainly a lot of skepticism with the Clean Power Plan's statutory reading from the Chief Justice, but the majority opinion said, look, there can be plausible readings on both sides. And so that would put you in Chevron step two territory. And so we see the court applying this major question canon. So even though Chevron wasn't officially part of the case, I think it will be interesting to see if this is another way that perhaps the court is chipping away at it.
Thanks, everyone. That was a really helpful discussion of a really important case. So just for the folks who are listening in and want CLE credit, we're going to announce the CLE code, and then with that, we're going to move on to another case that was decided on the last day of the Supreme Court's term in a somewhat unusual term, having the two last cases of the term be administrative law cases was kind of a standout. So this case was called Biden versus Texas. And Ben, could you tell us what the case was about and what the Supreme Court held?
Yeah, so this was another case involving a change from the Trump to the Biden administrations, this one relating to immigration. President Trump had established what the court calls the Migrant Protection Protocols. You may have heard of it referred to as the Remain in Mexico policy. But the idea was a federal policy that any non-citizens who were apprehended in the United States after entering from Mexico would be returned to Mexico while their removal cases were adjudicated, which can take years. President Biden suspended the program the day after his inauguration, and the Department of Homeland Security later formally terminated it. Texas and Missouri sued, saying that the termination of the policy was unlawful. So this is much like West Virginia v. EPA in the sense that the court was reviewing the lawfulness of the termination of a policy, but there it was the Trump administration's termination of an Obama policy. Here it was Biden administration's termination of a Trump policy. And yet again, I should point out at the outset, the court didn't cite Chevron. Legally, the main question here was whether the Immigration and Naturalization Act forbids the president from paroling a group of individuals into the United States while their removal proceedings are adjudicated. And there were two provisions of the INA that were kind of interacting here that the court was addressing. The INA says that the federal government may, and that's the statutory term, may return a non-citizen who arrived by land to the contiguous foreign country that they arrived from, pending their adjudication. Another provision says that a non-citizen who is not clearly and beyond a doubt entitled to be admitted to the United States shall be detained pending removal proceedings. But DHS has never had the resources to detain everyone. And so in essence, the question here was, if DHS can't detain these individuals, is it required to invoke its discretionary authority to return them to the place that they arrived from for the individuals who arrived by land? And by a 5-4 decision, the Supreme Court held that no, the federal government doesn't have to return all non-citizens that it's not detaining to the place that they arrived from. Chief Justice Roberts wrote the majority opinion, joined by Justices Breyer, Sotomayor, Kagan, and Kavanaugh. And in essence, the majority said that may means may, and so it's up to the federal government to decide whether to invoke the authority to return a non-citizen who arrived by land to the place they arrived from. If Congress had wanted it to be mandatory, it would have said so. And the court said that remains the case, even if we assume for argument's sake that the federal government is currently violating the separate provision on detaining individuals pending their adjudication. And by the way, the court noted the statute does also allow case-by-case parole. So it's not clear that the federal government is in fact violating the detention requirement, but it didn't decide that either way. And I think maybe what drove the majority, in addition to kind of this plain text may means may argument, was the concern that there are significant foreign policy ramifications of concluding that the return provision is mandatory. And it would be inconsistent with how every previous administration before the Trump administration understood the statute. And I think the majority saw those foreign policy concerns as reasons not to read the statute as mandatory. There were two side issues that I'll just mention briefly, but in the interest of time, I won't get into the details. First, there was a question about whether the federal courts even have jurisdiction to review or enjoin an immigration policy like this. The majority found that it could review this, although it also said that the lower courts didn't have the authority to issue an injunction against the policy. And second, there was a question about which document the court should be reviewing here. There were two separate actions by the Biden administration repealing the program, one of which was issued during this litigation after the trial court had said that the original explanation was insufficient. And there was a question about whether the court should be looking only at the first one, the pre-litigation decision, or the second one, which was issued during the litigation, in particular to determine if the federal government had adequately explained the reasons for its change in position, which is always a potential APA issue when any agency changes its position. The majority said that the second one, the one issued during the litigation, was final agency action. It didn't address whether it actually gave an adequate explanation for the change in policy, but it sent it back for left that for a decision on remand. I guess I should point out that Justice Barrett's dissent said she agreed with the majority on the merits. She just thought the court should vacate and remand without addressing the merits because the lower courts misconstrued the jurisdictional statute. So I guess really there were 6 votes on the merits to uphold the repeal of the policy. And Justices Alito, Thomas, and Gorsuch dissented on the merits and also joined Justice Barrett in concluding the court should just vacate and remand. It's interesting to note that this issue originally came up on the government's motion for a stay of a trial court order invalidating the repeal, and the Supreme Court denied the stay on the ground that the government was unlikely to prevail on the merits. And then, of course, the government did prevail on the merits, which could suggest that at least one vote flipped based on full briefing or argument. It also could be that this additional explanation that the government gave during the litigation was what persuaded somebody. But that's another data point in this discussion that we were having about the shadow docket and the value of full consideration on the merits. And then very briefly, in terms of what this may mean for future admin law cases, I think in most respects, it's a pretty narrow decision and probably doesn't signal much beyond the specific statutory context that it addresses. But I do think this discussion of the side issue about which decision the court could and should review kind of gives a roadmap to agencies for how to shore up explanations that don't seem to be standing up in court. So it may be important for that in the future.
Thanks, Ben. So the next case we want to talk about isn't quite an administrative or environmental law case, but could have potentially, big implications for the kind of balance of civil jurisdiction between states and the federal government and tribal governments. So it's definitely worth discussing, and we have a real expert on the case itself, Nathan, to tell us a little bit about Castro-Huerta and what the case was about and what the court held in that case.
Yeah, so in order to understand Castro-Huerta, of course, you've got to go a little bit back to the to 2020, October term 2019 in McGirt v. Oklahoma. So back in 2020, the court in a 5-4 decision held that Congress had never disestablished the Muskogee Creek Reservation in eastern Oklahoma, which is in and around the city of Tulsa. Because 4 other tribes have a similar history as the Creek, this meant that basically all of eastern Oklahoma was Indian country. The court got there by saying, even though no reservations had been recognized in eastern Oklahoma since statehood, the federal government had never treated it as such. The tribes generally disclaimed its reservation status for about a century. Congress, the court said, never actually enacted a statute saying the right words to end the reservation status of the land when Oklahoma became a state in 1907. So the court said, we start and end with the text. We don't find the text that we're looking for to end the reservation, and therefore the land is still Indian country. Well, what does that mean? For those folks who are not familiar with Indian law, as I was not circa 5 years ago, this all can be quite confusing. And it doesn't mean, so there are different terms used. Sometimes people use the term Indian country, sometimes use the term Indian lands. Sometimes people use the term reservation. Indian lands is sort of a separate term that has different definitions depending on the statute. I don't use that term. A reservation is just a species of Indian country. And in this case, they're one and the same thing, so I'll probably use them interchangeably. But it's not about who owns the land. If you owned your house in Tulsa, you still own your house in Tulsa, even though it's part of a reservation. And it's not that it's no longer part of the state. It's still part of the state of Oklahoma. It's just that on pieces of land that are not Indian country in the United States, you're normally governed by two sovereigns, the federal government and the state government in any of its subdivisions. And how you divvy up that power is sort of the topic of many areas of constitutional law. In Indian country, there are three potential sovereigns that govern: the state government, the federal government, and the tribal government. And how you divvy up those are oftentimes defined by statutes that Congress enacted. So in the case of McGirt, which involved a horrific series of rapes by a tribal member against his 5-year-old step-granddaughter, who was also a tribal member, the rule was set forth in a statute called the Major Crimes Act. It says that certain enumerated major crimes committed by an Indian on a reservation were within federal jurisdiction, and the court had held several times that that jurisdiction was exclusive. So that answered the question of, okay, on a reservation, how do you divvy up the power when it comes to major crimes committed by Indian? On a more practical level, McGirt really changed the landscape of Indian country by making a lot more people now subject to the rules of Indian country, with 2 million people in eastern Oklahoma. And that population is primarily non-Indian, unlike in other large reservations where the populations are primarily Indian. And I'm again going to use the term Indian because that's what's used in federal Indian law. I recognize that other people have preferences for other terms like Native American or tribal members, but I'm going to use the term that's common in Indian law. So this kind of raised the question about, well, what of other types of crimes? For non-Indian on non-Indian crimes on a reservation, the court for the last 120 years had recognized that those are within state jurisdiction if the reservation's within the borders of a state. The question in Castro-Huerta was, well, what about non-Indians who commit crimes against Indians? That's not covered by the Major Crimes Act, and it's not covered by the court's prior holdings. The court had suggested in dicta several times that those crimes were exclusively federal, but the court never had actually explained why or actually said that in a holding. So with thousands of these types of crimes happening every year in Oklahoma, and the federal government oftentimes not prosecuting those crimes, Oklahoma asked the Supreme Court whether it had concurrent jurisdiction with the federal government to prosecute crimes against non-Indians, crimes by non-Indians against Indians. And that case was Castro-Huerta, which concerned a non-Indian who severely neglected his disabled daughter, who was a member of an Indian tribe based in North Carolina, but the crime occurred in the Cherokee Reservation in eastern Oklahoma. In a 5-4 opinion written by Justice Kavanaugh, the court held that those crimes were within the concurrent jurisdiction of the federal and state governments. They're in federal jurisdiction because there's a statute that's called the General Crimes Act, also called the Indian Country Crimes Act, that extends federal law to Indian country. And they're within state jurisdiction, the court held, because nothing in that federal law or any other federal law said that the federal government's jurisdiction was exclusive or otherwise preempted state jurisdiction. In other words, it looked at it from a standard preemption issue, which of course assumes a premise, which the court clearly stated, that absent preemption, a state has criminal jurisdiction within its borders. Now, there was a time before even the existence of Indian reservations when Indian country and state borders were distinct. Chief Justice John Marshall said in a famous case called Worcester v. Georgia that state laws have no force whatsoever in Indian country. But changing congressional policy, including creating reservations within states or creating states around reservations, meant that that was no longer the court's view for a long, long time. Justice Thurgood Marshall said so in 1980. Justice Scalia quoted him as saying so in 2001. And when Thurgood Marshall and Antonin Scalia agree about something, it's hard to say that that's kind of controversial. Indeed, the court had long recognized various forms of state jurisdiction on land that was both within the borders of a reservation and within the borders of a state, like crimes committed by non-Indians against other non-Indians. So in Castro-Huerta, the court said that the state presumptively has jurisdiction over people within its borders, and no statute preempts that jurisdiction when exercised over a non-Indian on Indian country. But the court didn't end the inquiry there. It said that maybe the state might not have jurisdiction if the tribe's self-government on the reservation means that the state jurisdiction would interfere with that. And the court said that that would not be the case in this situation. Self-government means that, for example, the Cherokee Nation gets to govern Cherokees on the Cherokee Reservation, but here the state is exercising jurisdiction over a non-Indian. And the federal government doesn't have their jurisdiction interfered with because the double jeopardy clause doesn't preclude the state and the federal government both from prosecuting the same crime. And the tribal government, according to a decision from the 1970s called Oliphant, doesn't have jurisdiction over these crimes. So the fact that the state was exercising jurisdiction wouldn't interfere with tribal sovereignty, a sovereignty that the tribe didn't have, except in discrete instances, which didn't apply in this case. So that was the basic outlines of the case. Some people have called it a tribal sovereignty case, but given all of what I just said, I think it's better to think about this as a state sovereignty case, since it's clear that the tribes didn't have sovereign authority to prosecute that crime. And a way to kind of sum it up or to think about it, especially in relation to McGirt, if the holding of McGirt was that eastern Oklahoma was within reservation borders, then the holding of Castro-Huerta was a reminder that the land is also within state borders as well. What that dual reality means for other cases going forward, I think, is still yet to be worked out.
Thanks, Mithin. So we have a couple more cases to get to, and then we want to just briefly preview a couple of cases the court's going to hear next term. So if anybody, works for state or local government and seeing all these developments in administrative and environmental law and really wants to get in on the action, the court heard two cases about how to get into these cases once they've already started. So Stephen, can you tell us a little bit about the court's focus on intervention this term?
Sure, and I won't get into too much detail in both of these cases, although I encourage people who are interested to look at the background because they involve the kind of high stakes drama that I think everybody who's works in the state AG's office has been involved in at one point or another. So these are two cases where multiple state actors wanted to represent the state's interests in federal court. And in both cases, an absent state party sought to intervene, even though another state actor was already in the litigation. And in both cases, the Supreme Court ended up saying that they should have been allowed to intervene to participate in the litigation. The first case is called Cameron versus EMW Women's Surgical Center. The underlying lawsuit was by a healthcare provider who sued various Kentucky officials over an anti-abortion statute. And the litigation was proceeding with the state health department under the auspices of the governor there. The state attorney general had been a part of the case, but had been voluntarily dismissed without prejudice sort of very early on. Things came to a head, though, when the political parties basically switched hands on both directions. And the state health department, after a permanent injunction was issued and that decision was affirmed, decided that it was not going to challenge that anymore. It was not going to defend the statute, allow the permanent injunction to come into effect. And at that point, the attorney general, who again switched parties since the early litigation, wanted to come in and participate in the litigation in defense of that statute. So one party was exiting, and then the attorney general wanted to come back in. And the Supreme Court held that the Kentucky Attorney General should have been allowed to intervene to defend the state law. It noted that there were what it called deeper constitutional considerations here, not any specific federal rule. And it identified that consideration as the state's sort of overriding sovereign interest in defending the enforceability of its own statutes. And even though this was a case where the state, you might argue, had exercised that power by deciding not to defend its statute, the Supreme Court noted that Kentucky law had empowered multiple officials to defend the state's interest in federal court, including the attorney general, and relied upon that statute to say that the federal court should have allowed the Kentucky AG to step in to defend the law. So that's Cameron. The other case is Berger versus North Carolina NAACP. And that one was a civil rights organization's challenge to the North Carolina voter ID bill and constitutional amendment, I think. And this case was a little bit different because here the state defendants were being defended in court by the North Carolina Attorney General. Josh Stein, and there wasn't a change at the time. So the state AG was still in the case, defending the Board of Elections and other state officials, and defending the law, although there's a dispute about how much. And the absent state party that wanted to come in were these two legislative leaders, one from the House, one from the Senate, who wanted to come in because they said, and I love this terminology, they said that the AG was providing only a tepid defense to the state statute, and made a point of saying, which is all true, that the state AG in his previous life had actually voted against an earlier version of this law and had spoken out against it. So sort of his heart wasn't in the defense. Again, the Supreme Court said that the legislative leaders should have been entitled to intervene and should have been permitted to intervene. I'm sorry. And it again relied on the fact that under North Carolina law, it explicitly authorized the legislative leaders to come in defense of state statutes. Now, the thing that was interesting in Berger, as opposed to Cameron, was that, so again, in Cameron, the state was trying to get out of the case, and the court said somebody should come in to defend the law. Here, the state AG was in the case, was staying in there and was at least facially defending the statute. And that raises the question under intervention standards of whether there was already a state party who was adequately representing the interests that these legislative leaders wanted to propound. And the court got around that, and this is a change in the law, by saying that when a state has already allowed multiple actors to participate as litigants, the ordinary presumption of adequate representation is no longer appropriate, right? And so basically took away that presumption and deferred to a state's decision to allow multiple of its actors to appear in court to defend a state statute. So I do think these cases are interesting, and I'll just say very quickly, I think 3 takeaway points from here. I mean, one is that the court repeatedly recognized what you might call a transcendent state interest in defending the validity of its laws that goes beyond the positions of any particular official who may be a party to the case. And I thought that was interesting, because usually if you think you're going to defer to the state, you defer to the state's position, including on the defensibility of its statutes. I think the court rejected that position in these cases. 2, the court sort of explicitly acknowledged that, at least for purposes of federal litigation, the state does not have to speak with a single voice. It's possible for the state to speak with multiple voices. And I find that interesting because state AGs are engaged in constant battles to be the only voices in their state and federal courts against agencies and elected governors and others who want to instead speak on behalf of the state. But the third point that I think is probably has the greatest implications, especially for administrative law and environmental cases, is the court was obviously taking a very practical approach to the question of intervention here. I mean, each of these cases was factually a little bit different, but at the end of the day, what the court said was, this is super messy. It is super messy here. Somebody should be in here litigating this case properly. And one thing the court did in both cases was to brush aside jurisdictional and other concerns that had been raised to allow that defense to be raised and to allow the courts to have an adequately presented case where they could issue a ruling. And I think that type of practical consideration is likely to be something the court will look back on when it decides in future administrative cases who should be allowed to participate.
Thanks, Stephen. So there are actually more cases that we could have included in this presentation from this term, and there's certainly more that we could say about all the cases that our panelists have been discussing. But in the interest of time, it's worth discussing 2 environmental cases that the court has on its docket already for the first argument session of next term. So Lindsay, could you tell us what the issue is in Sackett versus EPA?
Sure. So Sackett starts with actual people, the Sacketts, back in 2007, who did something that a lot of homeowners do. They wanted to, make some improvements or, build out their home. And they asked the question of, what permits do I need and who do I need to get them from? And so the question here is, do they need a permit under the Clean Water Act? And that's a question that has high stakes on both sides. That can be a very time-intensive, cost-intensive process. Getting that wrong and saying you don't need a permit if EPA thinks you do can have some pretty steep statutory penalties involved. So this is a question that matters in terms of whether the permit's needed and whether it's required under the act. And the question that the court is going to look at is essentially, does the Sackett's land or the water features there qualify as waters of the United States? And this is a term of art because the Clean Water Act doesn't reach every water in the United States. Environmental regulation traditionally belongs to the states, so there has to be this federal hook. So the way that the statute works is it extends the Clean Water Act to these waters of the United States, WOTUS, which basically means navigable waters plus something close enough connected to them. And what that close enough is the question for the court. You know, a navigable water would be Mississippi River, navigable water. The creeks that appear in my backyard every time we get torrential rain, like we have the past couple of days, not navigable water. So the question that the agency and the courts have been wrestling with is, okay, it's not just the Mississippi River, something else is included in this category. How closely connected do other waters have to be to a navigable water or not? And this is another area where we've seen a lot of back and forth with the agencies. The past few administrations, we've seen one rule under the Obama administration, another rule under the Trump administration. As you can imagine, there was a lot of legal fights about this. These states on this call and many others were on both sides of the V in all of those. And this is an area where, again, with the new administration, we have more rulemaking going on at this time, and we don't have a clear answer on the agency side. Meanwhile, the Supreme Court has not been terribly clear on this issue either. There's a number of cases over the year that have asked this question: what counts as waters of the United States or not? I won't go into all of them, but the key case is really this Rapinos decision. And the reason that this has caused a lot of issue for lower courts and litigants is because there's only a plurality decision that Justice Scalia wrote that takes a fairly restrained view of what waters of the United States is. Justice Kennedy wrote a concurrence that said, okay, we're going to talk about a significant nexus between water features and navigable waters. And this idea first, is the significant nexus test controlling because it's the fifth vote, if you will, in the concurrence, or is it not because it's only a concurrence? And then what on earth does a significant nexus mean? These are the questions that the court is wrestling with here. And for the particular facts for the Sacketts, there's no dispute that there is no navigable water on their land. There's wetlands that are adjacent to other wetlands that drain into a ditch and a creek that eventually drains into navigable waters. So it is a real question of, some of those count as waters of the United States. Do all of them? And what is that standard? How do you tell the difference? This case has taken a long time to get up to the Supreme Court. There's been a lot of back and forth, some procedural fights about what court the Sacketts need to be in the first place. But now we have a decision where the Ninth Circuit had said the previous administration's view of what counts as waters of the United States does control. It gave a lot of weight to the Justice Kennedy concurrence. And so now the question that the Supreme Court has taken is, was the Ninth Circuit right that counts as waters of the United States? So this is another area where I think some of the issues we talked about earlier will be interesting to see how they play out. This is not strictly a challenge to the rule, so that's why the states here are not the named parties in this case. It's again the Sacketts who are bringing this in this potential enforcement context, but you still have the same issues we talked about earlier with different rulemakings and administrations changing, and should the court weigh in on this issue or not. And we also have the same issue where there's been significant uncertainty for years about what this statute means. So I think it'll be interesting to see what sort of clarity we do or don't get from the court on this long-standing issue.
Thanks, Lindsay. So right after the court hears argument in Sackett, the next week it's going to hear argument in a case called National Pork Producers Council versus Ross. Ben, will you tell us what this case is going to be about?
Sure. Yeah, this is a dormant commerce clause challenge to a California law regulating pork. The California law prohibits the sale of pork products unless the mama pig was raised humanely. It had to have had 24 square feet of space, could turn around in her pen. Most of the pork that's sold in California is raised elsewhere. And so the main question is whether this is impermissible extraterritorial regulation of conduct outside of California. The challengers, of course, say yes, because as practical matter, California is dictating how pigs are raised in other states. And California says no, because all it's doing is regulating the sale of products in California, which, of course, ordinarily it can do. This particular law is, I think, kind of innovative, and I'm not sure it's caught on elsewhere yet. But the legal issue about extraterritorial regulation is super important to states, and really states can get caught on both sides depending on whether it's our laws being challenged or whether we don't like what some other state is doing that's affecting conduct in our state. Just by way of example, Oregon's one of several states that has clean fuel requirements to combat climate change, where the ability to sell fuel in Oregon does depend in part on how much greenhouse gas was emitted elsewhere in producing the fuel. Those laws have been challenged on extraterritoriality grounds. And so far as I know, all of the challenges have failed, but we'll of course be watching Ross closely to see if the law changes on that. And I also know now that Roe v. Wade has been overruled, there's a lot of talk about the limits of what states can do to regulate abortion extraterritorially. So we may be seeing a lot more cases in this area in the future.
Thanks, Ben. Can I actually ask you to just say another sentence or two about what exactly the Dormant Commerce Clause is for anyone that might not be familiar with it?
Sure. The Dormant Commerce Clause is the clause that somehow is not in the Constitution, but we find it there anyway. The Constitution gives Congress the power to regulate interstate commerce. So the Supreme Court has long interpreted that to have a negative implication that there are certain regulations by states that are beyond the state power because of the way they affect interstate commerce, even though Congress hasn't spoken on the issue. I mean, of course, if Congress passes a law saying states can't do this thing in interstate commerce, that may have preemptive power, but the Dormant Commerce Clause is a doctrine that allows, under which courts review state regulation of interstate commerce, even when there is no federal law directly on point. As my description probably makes clear, that has been controversial in some years, in recent years, and I think Justice Thomas has said he doesn't think there's such a thing. So you may get some interesting bedfellows in a case like this.
Thanks, Ben. So we're going to switch over to a couple of minutes for questions from the audience to the panelists, which you can put into the Q&A function. But I'll ask one that came across earlier, which is whether the panelists have opinions about, looking forward from West Virginia versus EPA, whether this doctrine is going to kind of land in a place where it has objective factors and kind of gets mechanically applied, or whether there's a sort of inherent level of malleability in the doctrine that will just exist going forward.
Well, I've already, I think, expressed my view that I think this is potentially a very malleable standard. I saw one of the questions mentioned the case a couple of terms ago about the meaning of sex in Title VII and whether it included sexual orientation, transgender status, and those things. Was that a major question? I don't know. I mean, that was a very textual decision from the Supreme Court, but I think what the court is saying here now is that in these extraordinary cases, however you define those, kind of the plain meaning of the text, the most natural reading of the text is not necessarily going to be what controls, and that is at odds with how we normally at least start statutory analysis. But this isn't the only area where the court requires clear statements. I just think it's going to take some time to work out what this means.
Yeah, and I think it intersects with Chevron in interesting ways, because one of the justifications from Chevron initially was that, Congress was going to pass big statutes and allow agencies to fill in the details, and we'll defer to agencies in that detail filling. And the major questions doctrine is sort of the flip side of that, which is to say, well, but when agencies aren't filling in details, but actually making major policy decisions, we're going to do the opposite and not defer to them and make them stay within fairly strict bounds. And so, Chevron sort of being the word that should not be named oftentimes right now in administrative law litigation, I think has interesting intersections with the assumptions behind that doctrine and the counter assumptions behind major questions doctrine. How do you draw the line between those two things? And is there some middle category where the court just decides on the best interpretation of the statute, neither deferring to the agency or deferring to the party challenging the agency? Maybe Lindsay has an answer.
Well, I certainly do not have the answer to how major questions is going to work out going forward. I think one thing I will add is the elephant in the room here in all of these cases is the skepticism about what Congress is going to do, because the idea is the court is asking what would we assume Congress would have said if they wanted to delegate this power, but that of course assumes that Congress is going to take some of those actions. So I think the court's dealing with that reality. And then I think on the other side, it's also dealing with the reality that there are a lot of agencies who are trying to act in creative and new ways. Stephen can tell me if this is controversial. I think it's not. When the Clean Power Plan came out, the agency was really clear, and Obama was very clear. Congress hasn't taken this step, so we are going to do something aggressive on the agency side. And whether you agree with that or not, I think that's a reality that exists with a lot of these rulemakings on both sides of the aisle, whoever's in the White House. And so the court is trying to deal with the idea that we do have agencies who are trying to take new and creative steps, and what does that look like? So I think that is certainly something that factors into the court's decision. And I think that's something that we will see factor into lower courts as they are faced with the next question and whether it's a major question going forward.
And just to give some context on this, I do think one way we can answer what's going to happen in the future is to look at some of the past, right? I mean, Lindsay was absolutely correct in saying that the major questions doctrine may not have been labeled as such before, but has come up before in a bunch of previous cases. And as litigants know, what ends up happening is people pick famous lines from these cases and try to shape them for their own purposes. And I think we're just going to continue with that. This is not exactly a new project in the federal realm. We'll also add an element of like comparative law here, which is like states have their own version of the major questions doctrine. So New York has this infamous doctrine that's called Boreali, named after a case that was a smoking case and the major questions case, and cited Brown and Williamson. And the path of that doctrine in the state courts has been somewhat chaotic, right? Some things have been upheld, some have not, based on the nature of the courts. And so I think, and I assume similar things have happened in other states reviewing state agencies' powers. So I don't know this is like the most heartening answer to like what's going to happen in the future, but I do think the experimental evidence has been that it is difficult to figure out exactly precisely the line that goes into what's a major question and what isn't. And I don't know how optimistic any of us are that there will be a single answer to that in the near future.
So, this term, the court addressed a pretty important question under the Clean Air Act. Next term, it's addressing a pretty important question under the Clean Water Act. Is this like, just a happenstance of timing, or do the panelists think that the Supreme Court has some specific interest in environmental law, or maybe these cases fit into its broader interest in administrative law? How should people think about the kind of rate at which the court's addressing environmental law issues?
I'll start very, very briefly to agree with something Lindsay said. I do think this is an area where there has been significant rulemaking, and that might be part of the answer for why the court is paying attention to these cases. Because there are sort of self-conscious efforts by the agencies to tackle these big ticket problems, and for better or worse, the problems that we're facing just in the real world, not legally, so to speak, are things like, global warming, things like, water's drying up and coming back, and access to water. And I expect that places where there are the biggest problems to be the ones where the court pays the most attention on the administrative level.
And I'll give the optimistic read on that. Again, I'll start. I have skepticism about what Congress is and isn't going to do here, but I think there's also a read that because these issues are so critically important, the question of who gets to decide them matters. And knowing that answer sooner rather than later can have some value to it. The way that we had always pitched the West Virginia case is it wasn't really a question about what is the right policy solution on these issues, but it's a question of who gets to make that. And there's certainly pros and cons on either side, but from the perspective of the states I've represented, EPA has a critically important but singular focus on environmental protection, and Congress is able to take into account other factors, particularly for the states and region of the country who are going to be most affected by those transitions. So I think there is a way to look at this trend that however these questions are answered, if the court is putting the pressure back on Congress, maybe that makes Congress more likely to stop pushing these issues off entirely to the agencies.
That's great. So does anybody want to have the last word, or are we going to leave it with Lindsay? All right. Well, this was fantastic. You all covered so much ground in a relatively short period of time, and I really appreciate every member of the panel for their insights. And I want to turn it back to Bethany to wrap things up before we close.
Thank you, Kirti. Thank you, Ben, Mitten, Stephen, and Lindsay. That was a very engaging discussion, and I appreciate your engagement on these issues with us. Thank you to all of you in our audience for attending and for your great questions. For those of you requesting CLE credit, please fill out the form that you can find in the chat. And even if you aren't requesting credit, please fill it out and give us any comments or feedback you have. We've designed it so you can use it for either form of feedback, and we appreciate your feedback very much. Thank you all for joining, and we hope to see you again at our next event, and I hope you all have a wonderful